All right, ladies and gentlemen, let's go ahead and get started. Welcome to Senate Judiciary. We've got a lot of bills on the calendar, so let's go ahead and get going. We're going to take a couple things out of order, and I apologize in advance. We've got members from the House that Representative Treadaway is here. I understand he's got to get out of here and have a meeting, so we're going to call up, as soon as we take the roll, we're going to call up HB 188 first, and then we'll jump into the public hearing. Ms. Ogden, if you'll call the roll for us.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
Here.
12, and we have a quorum.
All right, good deal. First bill, like I just said, we're going to take out of order. We're going to let Representative Treadaway get out of here and get to his next committee meeting. Is HB 188. The floor is all yours.
Thank you, Chairman, members of the committee. House Bill 188 establishes the Alabama Law Enforcement Officers Family Scholarship Program, designed to provide financial assistance for college tuition and associated expenses to eligible dependents of long-term law enforcement officers. The program is administered by the Alabama Commission on Higher Education and applies to undergraduate programs at participating public technical schools, colleges, and universities in the state of Alabama. And if you have any questions, I'll be glad to answer them.
Senator Bell and then Senator Smitherman.
I'm going to do a motion for favorable, but I'll be glad to.
All right, Senator Smitherman.
I'm tagging with you.
How about you do a first, I'll do a second.
I'll second it.
All right, we've got a first by Senator Smitherman, second by Senator Bell. Any discussion on the bill? All right, Ms. Ogden, if you'll call the roll for us.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
Aye.
13 in favor.
All right, Representative Treadaway, the bill's given the favor report. Thank you for coming.
Thank you. Appreciate
Mr.
it.
Chairman.
Yes, sir.
I just want, Representative.
Mr. Treadaway.
Remember, we like the man on the other side of the cross with Lord Jesus. Remember us when we come downstairs.
So, I heard a lot of bad things about this committee, but you know what? As of right now, everybody's good.
You can't believe everything you hear.
All right, I like those comments, Senator Smitherman. All right, next up is HB 43, Representative Hill. We've got a public hearing called on that. We'll give Representative Hill an opportunity to explain the bill. We'll have a public hearing, and we will not be voting on that today. Representative Hill. Mr. Chairman.
Thank you, Mr. Chairman. I appreciate it. Split sentence simply means that a judge imposes a sentence, and then within that sentence takes it down to a certain number of years in which the individual must serve. Right now in Alabama, we do 20 split 5. That's the most we can do. This bill is 30 split 10. So if a judge gave an individual 30 years, he could split that down to 10. That individual had to serve that 10 years in the penitentiary. At the time he got released, he would continue to be under the direction of the judge. Of course, he'd be on probation. If he did something else during that period of time, he could the judge could resentence him, or as you know, resplit the split if that's what he deemed necessary. That's it in a nutshell. This is the same thing. We do it as 20 split 5. This is just a 30 split 10.
Senator Figures.
Thank you, Mr. Chairman. This is just on a lighter note. Will the female judges be able to do the same thing? You just kept saying he.
Freudian slip.
Like I said, it was
Freudian slip.
How
about
a light note.
How about that, Senator Figures? Freudian slip. Yes, ma'am.
Mr. Chairman, I want to ask you some questions that I think I know the answer to, but just for point of clarification, you mentioned that the current Alabama law allows for a 20 split 5.
Yes, sir.
And actually, I think some of the more heinous crimes would be eligible under existing law for that 20 split 5. Is that a correct statement?
I would say all of them, because a Class A felony, is 10 to life.
Okay.
So 20 is certainly within the 10, within that gap. So what this would be aimed certainly at the more serious charges, more serious crimes, where we wanted an individual to be in prison for a period of time. But yes, we can already give a 20 split 5 on a Class A felony.
And I did notice, if I'm correct, excuse me, under current law, if a judge were to give a 20 split 5 sentence or any split under current law, that individual could be brought back at any point in time under that split portion by the judge, even if he gave a 20 or she gave a 20 split 5, could be brought back the next day or year 1, year 2, year 3. But the provision that I see in here under this 30 split 10 seems to say to me that if somebody were sentenced to that 30 split 10, that the 10 years would be mandatory day for day, and the judge could not review them or bring them back within that 10-year sentence. Is that correct?
That is correct.
Okay. All right. Members, any other questions before we get to the public comment? Senator Bell and then Senator Smitherman.
As a young lawyer, I always waited for the day I could get you in this position. When you were the judge.
And I want you, Senator Bell, to take full advantage of it. And just remember the old adage that he who laughs last best.
I guess I better be good since you were always good to me.
I appreciate that. Thank you.
I think the issue that I have with our sentencing altogether is I can get a 30-year sentence today. Senator Stutz can get a 30-year sentence today. Senator Carnley can get a 30-year sentence today. Senator Albritton can get a 30-year sentence today. And we have the same jacket at DOC, and we're all four going to get out at different times. And there's no rhyme or reason why that happens.
That's true.
And I still understand our sentencing, how that works. When some can get out, I've seen them get out real early.
I've sentenced people to 15 years and had them out in 15 months. And I mean, you know.
And that's the one issue that I think this bill, at least, you know, they're going to be there 10 years.
Right.
Where a lot of times I've seen crazy things happen and they're out.
And if an individual offended after they're released, the judge, the sentencing judge, is the individual that has the authority to resentence that person to a period of time in the penitentiary, up to the 20 years that he has remaining on his sentence.
That's all I had.
Senator Smitherman and Senator Figures.
I'll be brief. Senator, I know exactly what you're saying. I will say this. I've had the opportunity, just like she's sitting right by him, to sit right by the judge. I was clerk in criminal district. And I've seen people serve just like these 10, and then they be out and they mess up. And the judge, you know, I'm talking about Judge Pete Johnson, that judge would bring them back. And this is what he would say to them. After the 10, he said, you trying to break back in prison. And he put them right over there and sent them right on back downstairs on that elevator. And like he said, then they'll resentence, especially if it's something heinous or something like that they've done. So, yeah, this flexibility. And you're right about the 5 years. They be wanting to give them more. That's why this 10 is great. They judges want to give, my judge did, but he couldn't give but the 5, you know. So, Judge, I think it's a great, good bill myself. And I'm all for these heinous people, you know. At some point in time, you just got to remove people.
Yes.
You know, I mean, at some point when, you know, and I'm going to say this, y'all know if y'all heard about on the news about this fireman that got killed up there at the fire station. And we finally got the guy, and the other one got shot. And this guy was one of these heinous people we were talking about. There was 2 or 3 other major things that he had done. So that's what you're doing with this bill. You're getting them kind of people completely off the streets and having a hand on them for 30 years after 20 more after the 10 to say if they don't, we're going to get you off another 20 years. So I just applaud you, Judge.
Thank you.
Senator Figures.
Thank
and
you,
Senator Albritton.
Mr. Chairman. Judge Hill, would you be willing to accept a friendly amendment to say all sex crimes rather than just sex crimes involving a child? I've received a note.
Are not subject to this. Is that what you're saying?
I just want all sex crimes included with where you have, okay.
Show me where you are,
Okay.
Senator. I've read this thing a bunch of times.
Right,
I can't say I got it
understand.
memorized.
It said when a defendant is convicted, oh, I'm sorry, on page 1, line 16, it says when a defendant is convicted of an offense other than a sex offense involving a child. I'm asking for an amendment to say other than a sex offense, period.
That is a Class A felony or B felony? To answer your question, ma'am,
Well,
if
let me
if
tell you
that's
what I'm trying
important
to do.
you, if that's important to you,
No, well,
sure.
this is why, and you tell me the best way to handle this. I had a constituent write me on this bill saying that a person had gone to prison for raping one of his family members.
Okay.
And they got out early and ended up raping someone else.
Well, they wouldn't get out for 10 years, so they wouldn't be getting out early.
Okay, so we're not letting those off. Okay, that's what I wanted
No,
to be
ma'am, it
clear
would
of.
be a 10-year minimum sentence served in the penitentiary.
Every day, okay.
Yes, ma'am, day for day.
All right, thank you. Thank you, Mr. Chairman.
Senator Albritton,
Thank you,
and
Mr.
then
Chair.
Senator Govan.
So basically what you're doing is you're giving a greater opportunity for the judge to keep someone in prison for a longer stint.
I am,
That's correct?
yes.
Okay.
And giving the district attorneys and
I follow.
something else to work with. And the district attorneys are in favor of this bill.
I'll follow you. And this also takes from a 20-year to a 30-year.
Yes, sir.
Does it, so if you have a 20-year sentence, you cannot do a split sentence?
Sure, you can do 20
You
split
can do
5.
20 split 5.
You just
So you're
can't
not
split it.
removing that, are you?
No, sir.
All right.
No, you can't do more than a 5 on a 20. This
just
lets you
giving
do
a
a
chance.
30,
I'll follow you.
a 10. Okay.
Fine. Just wanted to clarify that. The other thing, one other question is I see you've, on page 3, you've included some terminology there that you and I and others will have to have a discussion. Talks about an accountability court and then has some other subdivisions of those. We got to talk about those at some point.
No problem. I'll be
All
glad
right,
to talk about it.
I'm not certain how those fit into this in particularly, if they're handling this classification of crimes or not.
If you've got an individual that's in prison that has a drug problem and you get him out of prison, then this would give to the judge, again, this is all discretionary, would give to the judge the ability to put that individual into a drug court, which obviously, at least in my county, includes random drug screens, monitoring. What is it on a weekly basis? Daily? Okay. So I mean, it just gives you a thumb.
I'll follow you.
On that
I
individual.
just got some issues with the language and things.
No problem. I'll certainly
Thank you,
talk
Mr.
to you
Chair.
about it.
Senator Govan, and if there's no other questions, we'll go into the public hearing portion of the, Senator Govan.
Thank you. So, Judge, just a question, I mean, this is more just curiosity. It won't affect my vote, but, so I don't hear so much about the state prisoners being left in the county jails, but, you know, if a prisoner's sitting there a year in county jail, the way I read this is that they still got to do 10 in the big house, so to speak.
They're not supposed to be in the county jail for that period of time, Senator. As you know, we worked pretty hard a few years ago to incentivize our prison system to get people out of the county jail because they are charged a per diem rate to leave people in there. Part of what the county ACCA did not want was a situation where those individuals were sentenced to a county jail for the 10 years, and they are not.
Okay, thank you.
All right, sure.
And just for clarification, I thought we passed time served. So are you saying that somebody can sit in the county jail for, say, 2 years, and then if they got 10 years, you got to serve it in prison? But you're not giving credit for time served?
I defer to the judge on this, but I think if they sat in the county jail on 2 years waiting trial, that is credit that they would be assessed, that time credit through DOC
Almost
judges.
always we give credit for time served. Never known us to not do that. I mean, I don't guess you would have to, but as a general rule, judges give credit for
Yeah.
time served.
All right,
Yeah, it's confusing. Thank you.
you're welcome. Senator Smitherman, did you have a question, or do you want to go in we're going to go in the public hearing comment portion, and we're going to give each of, sure, yes, sir.
So the minimum of 10, would they still be eligible for good time?
No,
So it's a minimum of day for
years,
day
day
for
for day.
10, and then only after that would any of that begin to accrue.
well, after they get out, when they are released, they come back up under that same judge that sentenced them, or his or her, Senator Figure's predecessor, and it would, if the individual committed another crime or breached their probation in some way, their parole or probation in some way, it would come back to that judge for a resentencing. Now, that sentencing could be the balance of the sentence, or it could well be any portion thereof. Okay.
All right. Members, let's go ahead and get into the public comment portion. We've got a few folks signed up on each side. We're going to limit comments to about 2 minutes. And Ms. Ogden, I'm going to ask you to put a timer on them. First, Ms. Wanda Miller with Vocal. Ms. Miller, come on. She's an opponent of the legislation. Ms. Miller, good to see you again.
Good to see you too, and thank you for the opportunity to speak with you today. My name is Wanda Miller, and I'm the Executive Director of Vocal, Victims of Crime and Leniency. I'm here in opposition of HB 43 because there's tens of thousands of Alabama citizens whose lives have been affected by violent crime across this state. We heard them. We listened to them. My phone has been ringing off the hook with people telling me stories about their loss and how crimes affected them and how afraid they are that every day they see the chipping away of punishment for people who commit these crimes, who put no value on human life, who don't care about the consequences. And like Senator Smitherman said, and I'm a resident of Birmingham and have known Senator Smitherman for many years, yesterday we heard the news of a 22-year-old man who's charged with 14 murders in Birmingham. He shot 29 other people. A firefighter, Melton. A UPS employee whose mother grieves today. A 21-year-old female who was just minding her own business, living her life, and he killed her. And the list goes on. 43 families who can never go back to the precious moments before those incidents happened to them. And why was he still on the street? Why? Because our laws have been muddled up so bad. Our bonds are too available. It's too easy for people to commit crimes and recommit, and then we all stand back and go, what happened? That's our town, Senator Smitherman. Those are our people, our communities, where people can't sit on the front porch. A man in a wheelchair sits in his front yard under the tree and he gets shot just because he's available, just because.
Ms. Miller, I hate to do this. I know you're very passionate about it, and in our meetings that we've had, I know that. But I know 2 minutes is a pretty quick time to say. I would just say, and I ask the members to be open and engaging over the next week or so with Ms. Miller, the other opponents, the proponents of the legislation, and to continue to have those conversations.
Right. One thing, and I'm not going to take up a lot of time. One question I would have is, if this legislation passes, will it open the door for those who did not have the opportunity to be sentenced on a split, who are in prison right now on a 30-year sentence? And I know Representative Hill, and I hope you can answer this for me. Will we be looking next year or the year after at legislation that's going to bring those people back to be resentenced? We've heard that from so many victims that have called us. Is my sentence going to stand? Is the sentence for the person that killed my child going to stand? So that's something that I would really like to be addressed if you could do that,
Judge,
sir.
Judge, we'll get to that point in just a second. Thank you, Ms. Miller. Let's move on to a proponent, Judge Jeff Kelley. Judge
Thank
Kelley,
you.
thank you, Ms. Miller.
Thank you for allowing me to be here on behalf of the circuit judges. We normally don't take policy or issues to you or come to you for that, but we think this is just a tool for the judges as far as sentencing. Right now, judges have great discretion. You take a Class A felony, 15 to 99 years to life. That's a lot of discretion. We currently could suspend those for 15-year sentences. 15-year sentences to give probation. We also have the two split sentence acts already, where if it's 15 years or less, they can have split for 3 years and the balance suspended for whatever probation. 20 years, 5 years. This gives us another tool in the right cases to be able to dispense justice for the victims as well as to the defendants to give a known sentence. If it's 20 years in one day to 30 years, we can split that to 10 years. Knowing they're going to serve 10 years, no good time, no parole during that period of time. And they come back and they're supervised by basically the courts in probation for their probationary period. It's similar to what the federal courts have when you see a sentence and they've got supervised release for so much after that. This is the only way we have that in Alabama under a split sentence to allow us to have the control. The local judge that's elected, and look, no criticism, no unelected parole board, unelected Department of Corrections employees classifying somebody different ways so people get out at different times. It's been mentioned. The local judge that's elected that has to face the people will be the one to determine the sentence, how long they're going to stay. That sometimes is a good justice when you got the district attorney, can't find witnesses. Witnesses may not be credible, but they want justice for the victim, and it gives them another tool to bring to us to consider for justice in our system.
Thank you, Judge. Next up is Ms. Darlene Hutchison. She is an opponent of the bill. Darlene.
Good morning. Yes, I'm speaking in opposition to this bill. We've created a complex sentencing scheme over the many years that very few victims can possibly understand what an inmate is going to get. And I know that this bill is intended by some to fix that, but I think a good judge, and I hate to term it that way, but a good judge would use this wisely. But we do have, unfortunately, many lenient judges, and that's become increasingly the case, that could misuse this. I was kidnapped at gunpoint when I was 20 years old and fought to put the man that did this to me in prison. He did get a 20-year sentence. The district attorney tried to plead it down even less than that, and we ended up with 20 years. He served every year in DOC's custody. And I just see, and we've worked with so many victims, hundreds of victims who just don't understand when they leave the courtroom. And this is one more complicated scheme that between sentencing guidelines, presumptive sentencing guidelines, and parole and good time. And fortunately, Senator Weaver was very instrumental in helping to fix good time largely, because that was just a travesty for years, that victims just have no certainty when they leave the courtroom. And it's such a complex thing. And then when we say if they mess up, they can revoke them and put them back in prison, well, then you're just inviting another crime victim to suffer the consequences. Our parole board's gotten a bad rap on a lot of things. I don't think a lot of the facts are out there on how they operate. And even though they are unelected, and I completely understand that they are accountable on many levels, and I just think that if we can give certainty to victims, many of you know we have a constitutional amendment for crime victims, and that passed by 80.5% of the vote back in 1994. Victims are supported largely in the criminal by the public, and I think we owe it to them. I know y'all are dedicated to public safety, and making sure victims are engaged and have faith in the criminal justice system is an important element of public safety. We can't let victims lose faith. Thank you.
Thank you, Ms. Hutchinson. Next up, we have a proponent of the bill, Judge Charles Elliott. Welcome, Judge.
Good morning, ladies and gentlemen. It is my honor and privilege to serve the people of Morgan County as one of their 3 circuit court judges. First of all, let me say I sympathize with what some of these victims are saying as a former prosecutor about not knowing when someone's going to get out. What this bill does is it gives us certainty. Let's first of all, I want to go over who doesn't get good time. Folks serving a life sentence don't get good time. Folks on A felonies do not receive good time. Folks serving over 15 years on a sentence don't get good time. Child sex offenders don't get good time. Any crime causing death with a deadly weapon or dangerous instrument doesn't get good time, and that brings us to splits, which do not get good time. Splits, as y'all are well aware, mean day for day. If I give somebody a 20-year sentence split to serve 5 years, with 5 years of probation, they are going to serve 5 calendar years day for day, with 5 years hanging over their, with the 15 hanging over their head. And if they're on probation for 5 years and they screw up, I can send them back down for 15 years. So at least for that first portion of the split, I know where they are. This gives us that range of going to 30 and 10. So if that person serves 10 years day for day, I know where they are. And then when they're released, they're going to be under my supervision on probation. If they mess up, and they mess up big, I can send them south for the balance of their 30-year sentence. If they mess up small, I can say, you know what? I think you need to serve 18 months or 2 years, and then let's keep extending it. Let's keep extending it. And so that gives me a lot more discretion when it comes to the final balance of their sentence. Under current law, if I give somebody a straight sentence over 20 years or a life sentence, if there's no serious physical injury, that person's up for parole in 10 years. And then they're up to the parole board's discretion. This gives me, as a sentencing judge, the discretion and the authority to provide certainty, not only for myself, but for victims as well. And I thank y'all so much for letting me speak to you here today.
Thank you, Judge. Next up, we have Ms. Angela Harris, an opponent of the legislation. Ms. Harris. Good morning.
Thank you for letting me speak today. First, I can't be here without speaking and saying thank you to everybody who voted in for Ania's Law. I am Ania Blanchard's mom, and I'm a victim's advocate. I've always been a victim's advocate because I was a victim at 12 of sexual abuse, and then I was a sexual assault nurse in the state of Alabama for 22 years. I guess what my problem is, I have a problem with probation period for violent crime. I believe if you get sentenced, you should serve your time, and there should be even more years added to that. There's not enough time being added to these violent crimes. I want to give you an example. I went and spoke in Walker County a couple of years ago as a victim's advocate for a woman who had been almost beaten to death, and there were 7 other women behind her sharing their story in court in his trial, and he got 15 years. He's out. He only served 2 years, so he's out now. I just found that out this week. If the judge would have given him 15 years in one day, he would have served the whole 15 years. I don't necessarily understand our system. I'm trying because I'm working every day with victims, not only because of my history as being a nurse and taking care of sexual assault victims, but what happened to my daughter. The system failed my daughter. The system is one reason why my daughter is not here today. And I'm fighting for all victims of Alabama. I'm fighting for Ania. I'm fighting that people get justice. There's a video of my daughter that I put around. She's 5 years old, saying the Pledge of Allegiance. At the end of it, justice for all, and I play that all the time. We need to think about the crime victims and the justice. And in my opinion, justice is not being served to these victims, the crime victims of Alabama. They're getting out too soon. There's not resources. I would like to know where the resources are that are trying to help rehabilitate people that can be rehabilitated. I don't see that. And I promise you I'm working. I work with victims. I get messages every day, phone calls, and I'm not lying. I get them every day. They see me using my voice and they're like, please help me, help us. What can we do? Because the system is failing us. So I guess what I want to say is I just implore you to please do the right thing. Think about the crime victims of Alabama and their families. And I do know that this bill, if they're getting a sentence and yes, I want them to stay in jail longer. We want to have a longer sentence. So if this bill does that, I'm all for it. But also, people who are committing violent crimes should get higher sentences. And if they're getting a 30-year sentence, apparently they've done something very bad. And they need to stay in jail. And we need to make sure that they stay there, because that's not a long time. That's not a long time to be in there and to think that they're just ready to be out on the street. They're going to reoffend. So sorry, I'm very passionate about this, and but I thank y'all for letting me speak and let's do the right thing.
And Ms. Harris, rightfully so, and I'm proud to report, and I think you saw it in the news, that we were unanimous in the Senate yesterday on adding some crimes to Ania's law.
Yes, and when I heard that, I'm so thankful. I'm very thankful. Thank you to everybody for doing that. You just don't know the people, the victims of Alabama, how much they appreciate that. The state of Alabama, the people of Alabama, not even if they've been a victim or if they have family members of victims. That's what they want. That's what they want. That's what we want to see. We want to stand up and be proud of the state that we're from and say we're not going to put up with people just running our state in the ground and just killing everybody and committing violent crimes. Like, we got to put a stop to it. It's got to stop somewhere. So I think we're heading in the right direction. So I hope that we keep heading in the right direction.
Thank you.
Okay.
Thank you, Ms. Harrison. Thank you for being here. Next up, we have a proponent is Nettie Bloom.
Good morning, Mr. Chairman.
Good morning.
I'm Nettie Bloom. I'm with Alabama Criminal Defense Lawyers. I don't think y'all really thought we would be here. However, we are in favor of this bill. Unusual for us to align with the Office of Prosecution Services. We like aligning with the judges. We would like the committee to consider including some kind of retroactivity for sentences, and I know that that is not something you're in favor of, but in those very rare cases where the judge thinks that they maybe sentenced somebody improperly, that they could go back and re-sentence them with this split sentence. Thank you.
Thank you, ma'am. Members, keeping in mind that we've got a lot of work to do on the agenda, a lot left. Be glad for any discussion or any questions that anybody may have about the speakers. Senator Gavan had a comment, I think.
Thank you, Mr. Chairman. So,
and then we're going to go to Senator Carnley.
As I've told this committee many times, and I will probably tell you many times again, I don't do criminal work. This is not my world, but I've heard comments about good judges and bad judges, and I'm not going to say bad judges because I might appear in front of them one day, but I'll say judges that are overly lenient in their sentences, they're going to be that way one way or the other. What I'm hearing is we're giving a tool to the judges that want to impose a harsh sentence that is actually going to be carried out. So to me, even though I hear what everybody's saying, but where I'm leaning right now is that we're giving the judges another tool that want to keep people locked up, that are bad folks, and as Senator Smitherman said, need to be kept off the streets.
All right, thank you. Senator Carnley.
Thank you. I'm not a lawyer, so a lot of this is things you learn as you go. But, and as somebody that just, hopes the justice or the legal system takes care of the victims, the ones that have to deal with the aftermath, we hear, okay, you're sentenced to 30 years, and, we just expect it to happen. But my question is, so why 10 and not 15? Or why 10 and not 20? Why not do a split, give them 20 years, and hey, they're going to be in there for 20 years. Why 10? Where did that number come from?
Judge, if you want to come to the podium and address that question, and then.
The law in Alabama basically is that you're eligible for parole in 1/3 of your sentence. So I have sentenced plenty of people to life, realizing that in 10 years they would be eligible for parole, as I have sentenced them to 30, realizing that in 10 years they would be eligible for parole. I also know that during those period of time there were things that were done that often got that sentence, got that number of years diminished, lower than 10. And I think a 30 10-year sentence where you have a mandatory 10 years in the penitentiary is a good, I think it's a good tool for judges. I think it's a good bill. That's it. I mean, it's not nothing magical about it necessarily, but it's just in keeping with sort of generally the way that we sentence. And by the way, sir, it's not retroactive, and I do not intend to bring a bill to make it retroactive. Okay.
Thank you for addressing that. Senator Bell, and then if there are no other comments, we'll conclude the public hearing portion and move on to the rest of the agenda. Senator Smitherman will have comment or question after Senator Senator
I think
Bell.
the question about retroactive, we have splits that are less than 20. We have splits that are less than 10. You can do a 5-year sentence right now with a split of 60 days, 1 year. Creatively, it would open the floodgates, I think, on everything if you did that. So we couldn't. But as far as the splits, we do splits in the court system every day. I mean, I've seen 1 year split 30 days to serve. I've seen all kinds of splits. But actually, to go back to your question, they're not going to take that because they're going to get out in 10 or less anyway. Generally, I can tell you one of my last cases, and Judge Hill was. I know he probably won't remember, but he was the judge. It was a 30-year sentence because of the guy's history. 6 years he was out. And I mean, that was one of the last cases I had when I was in the prosecutor's office. And he was out within 6 years, and that wasn't the intent of the 30-year sentence back then. And that was just very frustrating.
Senator Smitherman.
Thank you, Mr. Chairman. What we're talking about here was in part why we established in the Sentencing Commission to try to bring some uniformity into sentencing. And when you said what you're talking about, you had situations, and I know it was related to violent things as well, but I'm going to give a small example. You had a person in one county steal a lawnmower, and they get a slap on the wrist. You had another person in another county steal a lawnmower, they get 5 years. It was just, it's kind of like what the lady was talking about. You know, you had this variation of it. In this particular situation, what you have, that bad person, if it's a split, the max they can get 5, you know, unless we pass this bill. Now, after 5, they can get right back out there on that street. Okay, but in this situation, they can get 10 before they can come back out on the street and it'll be supervised. So what you're doing here, you actually are making sure that you punish them more for that particular kind of crime, whatever took place at that time. I understand, you know, the concern people have when it relates to are they getting, is this going to make it easy for them or is it going to make it hard for them? And that's natural because many people, I say this all the time where I am, is that people who walk past the courthouse and everywhere else, they really don't know what's going on in there. You know, they see it, but they don't understand the process. So naturally, the apprehension will be there because they don't understand it. But in this situation, we're talking about keeping people where they need to be for double the time that you could do it on the 20 and 5. So I that's why I'm for it, because I know that we can keep people in continuously and be able to keep that 10 and then be over them again versus 5 and they go on about their business, you know. So I think in that regard that, you know, it's a very good bill, and I'm going to support it proper time I move.
Thank you, Senator Smitherman. All right, that's going to conclude the HB 43 for the day. I just asked members to, you know, talk amongst yourselves, reach out to the sponsor, Chairman Hill, listen to those other proponents of the bill, and certainly listen to the opponents of the bill, formulate an opinion, and then we'll have that bill back up in committee at some point. Thank you, Mr. Chairman. Next up is SB 81, Senator Kelley.
Thank you, Mr. Chairman and distinguished committee members. What this bill does, it strengthens the laws surrounding sexual misconduct with persons that are in custody. Specifically, the bill makes it unlawful for any person who has access to a person in custody due to their profession to engage in sexual misconduct with the individual in custody or correctional facilities or youth services or any of their enforcement settings.
Senator Kelley, thank you. I think there's a
Motion.
Probably a motion for a favorable report by
Yes.
Senator Smitherman and a second by Senator Weaver.
Good bill.
Any other questions? Yes, sir. Go right ahead, Senator Albritton.
Thank you, Mr. Chair. Who are you trying to capture here? There's already the law that an employee shall not engage in sexual conduct. That's an employee of the Department of Corrections, Youth Services, a sheriff, a county, or municipality. Also says that it's unlawful for a probation or parole officer to engage in sexual conduct. That's under supervision, disciplinary, custodial authority. And so my question is, who's left out from that? Who are we trying to capture?
Okay, so the issue that we have is we have these individuals, including attorneys in some cases, that are using their power over these individuals in these vulnerable states to get some consent in that. But it's any
Attorneys?
it could be a
You said
custodian, it could be anybody that is in that position. So.
All right, any other questions or comments? I know there have been several instances around the state, and I hate to say this, but involving attorneys who had clients that were in custodial care who have been investigated or charged, and so
Yes, sir.
I'm in favor of the bill. Any other questions and comments? All right, got a motion for favorable already, I think, by Senator Smitherman and a second by Senator Weaver. Any objection using previous roll? We do. Should be a good roll. All 13. All right, hearing no objection, bill's given a favorable report. Thank you so much, Senator Kelley.
Thank you, Mr. Chairman, distinguished committee members, and Senator Albritton.
Nothing
right.
wrong. Nothing wrong with getting homage to the budget chair.
Next up is SB 178, and I have the pleasure of carrying that bill. This is, members, this is what we've deemed the Speedy Trial Act. This would give the district attorneys in the circuits around the state the ability, or the AG's office, if they were handling a specific case. Got a motion for favor, Senator Bell, second, Senator Weaver. Senator Gavan, I'll let y'all fight it out for the second. Yes, ma'am.
Does this bill include funding for additional resources that goes along with the additional judges?
Senator Albritton, Senator Coleman Madison. That's a question he always asks about the funding.
He's on my hit list now.
Yes, it does.
Right.
If you look on line 89, the Speedy Trial Fund is created by the State Treasury. Monies in the fund at the discretion of the Chief Justice may be used exclusively for expenses authorized by this section and shall be budgeted and allotted in accordance with, and it cites the code section. So there is money available. There will be a fund that's set up and that will be funded. Any other questions or comments, Senator Albritton?
That question had been asked previous to coming in, all right?
I knew that.
We have an answer. It's not completely satisfactory, but it's okay for now.
All right, very well. All right, members, any other questions or comments? Seeing none, any opposition using previous roll? All right, bill's given favorable report. Members, just as an FYI, I'm going to turn the meeting over here in about 10 minutes to Senator Gavan. I've got an appointment that I've got to be at, but up next on the agenda, Senator Smitherman is SB 138, and I believe you've got a couple of potential amendments on that as well.
Yes, sir, I do. This bill is a bill that our Director of Pardon and Parole, former Senator Ward, is bringing before us at this time. And this bill amends existing Alabama law pertaining to obtaining of an occupational professional license upon the issuing of an order of limited relief and provides procedures for the review of applications for such licenses by certain occupational licensing board and make other revisions. One of the significant revisions is 12-26-7B is amended to repeal service of petitions for limited relief by the circuit clerk. The second one is that 12-26-7G is added to make individuals required to register as a sex offender or convicted of a violent offense as otherwise defined by law ineligible to obtain an order of limited relief. The third one is 12-26-9I is amended to allow for the creation of the rebuttable presumption of rehabilitation and fitness for licensing upon the entry of an order of limited relief. 12-26-9J allows for the entry into evidence an order of limited relief in a judicial administrative proceedings alleging negligent hiring on the issue of the hiring entity due care in hiring an individual if the entity knew of the order of limited relief at the time of the hiring. 12-26-9K is added to allow for immunity of an employer with respect to a negligent hiring claim if the hiring employer knew of the order of limited relief at the time of the alleged negligence hiring, provided, however, that no immunity is provided to the employer for other claims.
Senator Smitherman, Senator Orr, I think, has got a motion that you'll appreciate. It's a motion for a favorable.
I got a couple amendments.
That's right. Let's get them. If you could just briefly tell us what the amendments are, and we'll try to get those, if they're favorable, get them adopted, and then move it along.
All right, I have a copy for everybody if they need it too.
I think that should be in the package that Ms. Ogden's given to everybody already, Senator Smitherman.
Oh, okay. All right. The First Amendment just basically it replaces line 81 through 85 on page 3 through 4 with the following: B, once a petition has been filed, then it scratches out the clerk shall serve the petition. So it scratches that part out, and it says the court shall review. And then the next one is replacing line 286 on page 11 with the following: this section and section 41982 do not apply to any licensing requirement imposed by an interstate license compact.
Got a motion for favorable on the amendment. Second. Any opposition using previous rule? Senator Elliott.
I have a real quick question, Senator Smitherman. So the first part of the amendment on 81 through 85. So instead of the Occupational Licensing Board renewing or looking at the petition and making a determination, you have the court making that. Is that correct?
Yeah, instead of the circuit clerk. See right there where it says scratch through the circuit clerk.
Yeah, but she's
before
prior to that, he or she, Senator Figure, are sending that to the Occupational Licensing Board, and now it's just the courts reviewing it. Is that correct?
Well, I think the biggest thing I want it kind of reached that way, but the biggest thing that I can be certain to tell you is that the court took jurisdiction over reviewing it.
That answers my question. Okay. Thank you, Mr. Chairman.
All right, we've got a first and a second on adoption of the First Amendment. Any opposition to using previous rule? Hearing none, the amendment's adopted. You've got a second amendment too, Senator Smitherman?
Yes, sir, Mr. Chairman. It says they replaced line 230 on page 9 with the following.
Got a motion for favorable on the amendment. I have a second by Senator Singleton. Members, any questions, comments, or concerns about the second amendment that's been offered? Hearing none, any opposition using previous rule on that second amendment? Hearing none, second amendment's adopted. Back on the bill as amended. I think that we had a previous first by Senator Orr on that, and Senator Weaver, do you have a comment or question?
Yes, sir. I have a question for the sponsor. So in this, I believe, and I can't find it, there was some way that medical and dental were excluded from this. Is that correct?
Well, I'm glad you asked that because I was going to have to comment afterwards. You know, if that hadn't come up, I was going to tell you. You know, what is my understanding, in fact, they came by the office this morning, is that the Alabama Board of Pharmacies wants to have the opportunity. That's an amendment they want us to bring on the floor to give them the opportunity to vet those people prior to them being able to, these people we're talking about being able to be employed because, you know, they're going to deal with dispensary of medicine and everything. So they actually, I'll just tell you what they actually mentioned to me. They said that if, you know, at first they talked about just, well, no. And then we had discussion about, well, suppose somebody's got bad checks. There's nothing about they can't be around them. They just wrote bad checks. So then they said they were going to get this amendment the way they wanted us to present it, but it's going to bar people from being able to get their hand on this hiring people to let them get their hand on that medicine back there.
Right, that was my question. So you'll be bringing an amendment on the floor related to that?
I will.
Okay, I'd like to work with you on that.
Okay, that'll be fine. Yeah, I see why you do. You the medicine lady.
Senator Albritton.
Okay.
Thank you, Mr. Chair. I got two questions. I'm supporting your bill, all right? I want you to know that. Two questions, though. Number one is, on page 5, you've got some changes here where it talks about individual required to register as a sex offender pursuant to Chapter 20, Title 15, or convicted of a violent offense as defined. And then the other matters dealing with folks that are convicted or been in prison or something. But if I may be wrong, but some folks that are required to register have no convictions. If that's correct, if that's a fair statement, then we're taking folks of where accusations may be knocking them out of employment or particular licensures. I think we may need to look at that as a matter.
I'll be glad to look at that. And
Just a
I
thought.
know where you're going with your thought, and I really kind of agree with you. I just want you to know that, because I can trace your thoughts. And
You're one of the few.
You give me a little, they don't know, but you give me a little tutoring on tracing your thoughts.
The other aspect is I just want to call this body's attention to, this is the second bill now that we've had this body today that has the natural effect will be that we have more people within prisons. And whether it was Judge Hill's bill or this bill, both will have the same effect, keeping people out of employment and out of and in prison. And so while this is a great thing to be doing here and keeping safety, there's another side to that coin which we need to be aware of. And I just want to make sure that we're understanding that we've got a balance. Other than that, I'm all for it.
Thank you, Mr. Senator.
Got a budget chair that's got a question over here. Calling the question. Yeah.
He's telling me to shut up, okay?
All right. Bill has been amended, 2 amendments on there. Yeah, I think both of them are on. Is that right, Ms. Ogden? So, motion for a favorable on the bill as amended. Had a first, second by Senator Albritton, and any opposition use the previous roll. Hearing none, bill as amended is given a favorable report. Thank you, Senator Smitherman. I'm going to turn the meeting over now to Senator Gavan.
Okay, next up, I believe we've got Senator Orr, SB 89.
Thank you. This comes from a judge back home. It would save costs for the Department of Corrections and where they would serve warrants in the prison, and potentially the prisoners could serve concurrent sentences if it's a lower sentence for them. And I'm working with Mr. Williams with a small amendment on the timing. That would be Section C, but that's kind of a small deal, how frequently they would do it.
Mr. Chairman,
Yes, Senator.
at the proper time, I'd like to move for a favorable report.
I'll second.
So we've got a first and a second. Any further discussion? Any objection to using previous roll? Okay, so therefore we're going to proceed with the previous roll. That's got a favorable report.
I just want to, before he leaves, because I'm going to be following him in a minute, he know that. But before he leaves, that I think that's great, because I've been in situations, you actually got that joke in court, and they can't serve them. I mean, it's sitting right there, and there's a warrant for him, and they say, well, so I think that's great. I just tell you.
So, all right, so SB 89 is given a favorable report. So, clerk, if you call the next bill, please.
SB 183 by Senator Carnley.
Senator Carnley.
Mr. Chair, this is a bill we had last year and ran out of time on it down in the House, but worked with the Machis Indian tribe, Lower Creek Indian tribe there. They would like to, have the ability to employ their own police force. Have to be APO certified. They can only operate, on the tribe or the reservation.
Senator Smitherman.
When we get through with all that, I just got a question to ask.
Okay.
I'll second
So
him.
there's been a motion for
I'll
favorable.
second
Is there a second?
I'll second him.
Okay.
And I just like to
Discussion, are you recognized?
Thank you. Senator, the only concern that I have, and of course, I realize what situations that exist. And on top of that, I'm looking at the Grulu on the right side of you, or what I'm getting ready to say. Oh, you the Grulu to this. But my thing is this, is that what they're trying to hire an officer, but what are going to be their procedures of dealing with violations of the law? Because, see, in some situations, based on whether it's the tribe or not, the state laws don't govern these people. It's tribal law if you're on there. So you could do something that's out here. And so I'm just wondering, under this situation, are they under state law or tribal law? And I you know.
Yeah. No, so currently the county sheriff has jurisdiction over that, but what they wanted was somebody like if they had events that they, could know they were there all the time, or if they want somebody to live on the reservation, to be, the enforcement officer rather than having to call, because they're in the very northwestern part of the county, and a lot of times they don't have somebody out there in case somebody were vandalizing or, a thief. So this would give them if they could hire and employ their own. Again, it's all on them. No state dollars, no local dollars. They have talked to our sheriff's department. Sheriff's department's agreed, and everything's good with them. That was a question we had last year. Have they communicated? Because at the end of the day, they can make the arrest, but then it's the local court system that has to process them and handle them. So same laws, same sentencing, everything. They would just have somebody that they could employ to live on the reservation, if they so choose. If they can't afford it, they don't have to, the county sheriff would still have jurisdiction over the property.
Okay. That was part of my answer, but I'm not going to push you for the other part of it. We'll figure that out, because I'm supporting your bill, what you're doing.
Any further discussion? Senator Singleton.
Yeah, I can support this bill. I can remember a few years ago we gave another state tribe the same ability to be able to have their own police. Because they're not federally recognized, therefore they have to fall under state laws. And the sheriff still has jurisdiction to go on and make arrests whether he wants to or not, so they can't stop the sheriff from coming on in the county. Okay.
So thank you. So if there are no further comments, is everybody okay with proceeding with a favorable roll or previous roll? Okay, so we'll give that bill a favorable report. Clerk, if you call next bill, please.
HB 27 by Representative Underwood.
Representative Underwood, and this is not an accounting matter.
This is not an accounting matter. It is a little different. It is a situation that directly came from an occurrence within mine and Dr. Stutt's district.
Move for favorable.
All right.
Okay, we've had a motion for a favorable. Is there a second?
For me.
What does this bill do?
Okay, well, let's let
just wanna know-
Representative Underwood explain it a little bit then. He was trying to help you out.
I appreciate it. Page 2 is the guts of the change on line 45. No sex offender, adult, or juvenile can accept or maintain employment or volunteer position as a first responder, because what that does.
You can stop right there.
All right. Okay.
I'm ready to roll.
Yes, sir.
All right,
Yes,
so
sir.
I think we've got a first and a second. Any further discussion? Any objection to using previous roll? Okay, so we'll give that bill a favorable report. Thank you, Representative
Thank you very
Underwood.
much. Thank you.
Okay, Clerk, if you'll call the next bill. I'll tell you what, let's carry over for the moment HB 199.
Why are we going to do that?
Because Representative Hendricks is not here.
He's not here. Anybody handle it?
Unless somebody else here is going to handle it for him. He
Yeah.
was. That's why
But I'm
going to come back to
I
it.
got to go to a meeting, and I was trying to take up that deal with that bill because I got to go to ed policy.
Okay. All right,
And then
Okay.
we'll he and I talked about a few things that I wanted to kind of look at it a little bit with
Okay.
him, but I don't have any problem with getting it out.
Okay. Senator, you want to handle that? Okay, we have an amendment. That's why, and that's why I was gonna carry it, just winging it, but I didn't know about the amendment.
So I have an amendment that's been, basically vetted with the governor's office and the Board of Department of Parole. It still says the Board of Department of Parole would be that authorization, the people who will oversee the, monitoring. And now that these, let me read it. The Board of Department of Parole or any other state agency may electronically monitor an alleged delinquent child, released pursuant to the section of an alleged delinquent act, will be classified as any of the following if committed by an adult: a Class A felony, a Class B felony, a Class C felony, which is dangerous instrument or deadly weapon, as defined in Section 13A, will be used.
All right, motion for adoption of the amendment. Is there a second?
Second.
Okay, question?
So my question on the amendment, it says, or any other state agency. What other state agency would be electronically monitoring a child?
Well, you have, some child, DYS, their services do it also.
Okay. So any objection to adoption of the amendment using the previous roll?
No.
Okay, amendment is adopted. Is that the only adoption or amendment? Okay, so we've had a motion for, all right, so any objection to using previous roll to adopt or issue a favorable report? Okay, so a favorable report is granted for HB 199. If you'll call the next bill, please.
HB 190 by Representative Shaver.
Mr. Chairman,
Senator?
would you show me in favor of voting yes for this?
Absolutely.
And I'm gonna go to my meeting.
All right, thank you, Senator.
Thank you all.
Thank you, Chairman, members. HB 190 is the companion bill to SB 94, which Senator Orr has already brought before your committee. This is the companion bill.
Okay. All right, it's a motion for second for favorable report. Any objection to using previous roll? All right, Bill's given a favorable report. Thank you.
Thank you,
Representative
Chairman,
Shaver.
members.
Okay, so the last one I will carry for Senator Barfoot. I like carrying it like that. Okay, any discussion? It allows cooperative agreements between county and local governments for enforcement matters.
An amendment on it.
Well, there's an amendment. Thank you.
No, sorry. Here's the amendment. You got it? Okay.
Something is wrong. We have to pass a law to say that local governments can work together.
Yeah,
I agree, and I've got other frustrations on similar laws about working together.
but I just want to tell everybody it ain't our fault. Cause hey, we ain't the ones who didn't get on by the home rule.
Well,
That's why,
I mean,
they
I've been
can't
trying.
do nothing
I
in this state
understand.
without it. These simple things you just talking about. If we don't pass it, they can't pass it.
We really need to start looking at these things, because a lot of the things that come before us deal with local issues, of which you have locally elected officials on the county and the municipal level. And as a former elected person on the municipal level, I always hated to have to come down here with my hat in the hand big, and it just doesn't make any sense. We answer to the same people. So I think while we're working on everything else and trying to reorganize and streamline, we could cut our budget and our time and focus on state issues if we would allow local governments to govern themselves. Thank you.
Senator, that's a much larger picture, but as far as the business before us today, so the amendment, the amendment, the first thing is that we. So there's a number of municipalities that bleed over. City of Madison bleeds over into Limestone County as well. So I will make a motion to adopt the amendment that's been presented.
And what the
Second by
amendment
Senator
say?
Bell. So it allows the sheriff and the county commission of any county containing any portion of the city. So you know, so Birmingham could do a deal with Shelby
County.
County and not just Jefferson County. And then the next one is on page 2 of the bill. Let's see here. I'm trying to match it up. It takes any fees distributed to the office of sheriff for the sheriff pursuant to the memorandum may only be expended for law enforcement purposes. So, and it says in the county, so this just says for law enforcement purposes. So there's been a motion and a second. Any objection to using previous roles for adoption of the amendment? Okay, hearing no objection. Excuse me? All right, there's a motion for favorable,
As
and there's a
amended.
second. Any further discussion? All right, any objection to using previous role? All right, Bill's given a favorable report. We are adjourned, ladies and gentlemen. Move what?